Good afternoon. My name is Jonathan Lee. I'll be the moderator for this program, making the Northern District's ADR panel work for you. Some of you may be expecting to see Deborah Gittin as moderator. Deborah can't be here today, so I'm happy to stand in for her. I'm an assistant United States attorney here in the Northern District of California, participating today in my personal capacity. It has been my privilege to serve on the court's panel of mediators since 2015. I have greatly enjoyed working with litigants and their attorneys to craft a mediation process that is both responsive to their interests and helpful to their communication. It is a satisfying way to support the court's mission to provide early and informal access to justice. Let me now introduce our distinguished panel for today's program. First, the Honorable Sally Kim has been a magistrate judge since her appointment in 2015 and currently serves as the ADR magistrate judge for the court. In that role, Judge Kim is responsible for overseeing the ADR department, which among other things includes consulting with the ADR director on matters of policy, program design, and evaluation, education, training, and administration. Next, Jill Kopeikin is the ADR program director for the Northern District of California. Jill has been involved with the Northern District of California's ADR program for 30 years, first as a civil litigator, then as a panel neutral, and now as its director. As a civil litigator, she primarily handled intellectual property, complex commercial, and competitive employment disputes. In her role as an ADR professional, Jill has also served as judge pro tem for settlement conferences in Santa Clara County since 1997. She's acted as the co-lead of the Mountain View Community Mediation Program. She's performed mediations as a private neutral and has taught mediation theory and practice at Santa Clara Law School. Mindy Morton is a partner at Procopio, Corey, Hargraves, and Savage, focusing her practice on high-stakes litigation in healthcare, trade secret, technology, and internet-based disputes, and she leads the firm's healthcare and trade secret practices. Mindy is both a member of the mediation panel, and she also serves as an early neutral evaluator for the court. Bijal Vakil is a founding partner of Allen & Overy's San Francisco and Silicon Valley offices, and the global co-head of the firm's technology practice. Bijal's practice covers a wide range of technologies, from computer software to autonomous vehicles to blockchain technology. Bijal is a member of the mediation panel. Two quick administrative announcements. First, we will use Zoom login data to verify your MCLE credit. And second, we will save time at the end for questions. You can send your questions in the chat and we'll take up questions, time permitting, at the end. All right, so to get us started, let me throw it to you, Jill, and in your capacity as director of the ADR unit, can you give us a sort of sketch out a brief overview of the services provided?
Sure. Before I do that, I wanted to thank the Federal Bar Association and the Northern District Practice Program for inviting us to talk about the program. As Jonathan indicated, I have been involved with it in every capacity for the last 30 years, and I love the program. I strongly believe in its mission, and was delighted when the opportunity came to move into this new role. So in the new role, I work with the parties who come before the court, civil cases, and most of our civil cases are directed to some form of alternative dispute resolution. Through the courts program, we primarily offer two options: mediation or early neutral evaluation. We assume that most folks on the call will be familiar, at least in concept, with mediation, so I won't spend too much time describing that. We can talk more about the court's process as we move forward. Early neutral evaluation is a little bit different. Our district is somewhat unique in offering this service. It is an opportunity for the parties to get an early read on their case or on some very significant issue. It is a contested proceeding in the sense that everything is on the record. It does not involve, not on the record, it is confidential, but everything is done in joint session, so there aren't separate caucuses. And even though it is confidential, it's done more like a presentation, and then an evaluator will give a tentative read on what the parties' issues are. We can talk more about that as we go if you like. The third thing that we can do is we can work with the parties to make some kind of bespoke ADR combined, process. We can do arbitration. We can work with them if there are various needs. And that is by far the least frequently used, but it is an option. And as the director, I would be willing and able to work with the parties if they were trying to craft something bespoke. That's kind of the high level of what our program does. We also coordinate with, the court also has the options of referring things to settlement conferences, and many times the parties will go outside, but our program offers primarily mediation and early neutral evaluation.
All right, thanks. Could you say a little bit about how the neutrals on the mediation panel and the evaluators are recruited and trained by the court?
Sure. We have a neutral profile portal on our page. It's called Becoming a Neutral. And actually, I did put some material in the MCLE materials that were provided. I included pages of that. It's on page 16 of the MCLE materials. That excuse me, that's where it lists. It's further on 24 and 25 on how to create your own neutral profile. But what happens is the neutrals will go in, they'll create a profile application. We periodically open the panel to new panelists. It hasn't been open since 2019, but I'm hoping we will be opening it this summer to recruit new folks for likely to begin in the beginning of 2025. It takes some time. So they would apply there. We then collect the applications, go through them. My department goes through them. I would work with Judge Kim. We would then submit a list of candidates that we think are really viable candidates and work with the Judiciary Committee of Judges, who will then help us decide and, wean down to an appropriately sized list. That's basically the selection process. Once we have selected neutrals that we would like to invite, we send out invitations to them. They must be able to participate in our training program. We have a really strict rule that even though neutrals may have been mediating for decades, may have been a judge, may have been our judge, our chief judge went through our training program. Many of the magistrate judges who do settlement conference day in and day out, if they want to be on our panel, they must go through our program. So
our former chief judge, not our current chief judge.
Correct. Yes, that's correct. Former chief judge. Yes, thank you. So that's a pretty hard and fast rule. And that's because we take our training very seriously. And it's a really robust training, as all of you on this call know. It is done typically in 2 parts over 2 full days. And we do a lot of role playing. There's a lot of content delivered. And people get a real opportunity to train, to ask questions, to see how other folks do it. And we have a lot of practitioners who participate. So it's a very robust training process. Once they've done that, they would be sworn in, and then they would come and join our panel. Typically, we would do some shadowing, or I would work with them if they are brand new mediators, or my predecessor would have, and then they'll be off to the races. For the first year, our panelists are also required to participate in our advanced practice groups, and those meet monthly. Those practice groups, bonus points, they provide MCLE, as does our training, but they're very substantive, and both Bijal and Mindy are still in their practice groups, even though they have been on the panel for quite some time, because we bring issues up where, concerns, difficulties that we may have had when we're looking to brainstorm on how to use various techniques like mediator proposals and things like that. So they're very substantive. And as a consequence, the panelists get continuing training, and they also get MCLE credit. Finally, we do periodic reviews of, periodic trainings that are outside of that, where something might be certain specific issues. And that's just the overall process.
Thanks. Yeah, as someone who went through the training, I can vouch for its excellence, and the whole program of training and practice group and periodic training really gives you such a strong base of knowledge and understanding. It gives you access to other people who can help fill in gaps in whatever you might be encountering. So it's excellent. Thank you for that explanation.
Yeah, just one more thing to add, which is when I went through the program, I had been doing a lot of settlement conferences, but as you know, they're a little different than mediations. And I was interested in shadowing folks who had been in this program to make sure that I was compliant with, or had as much information as I had about how the process flows. And people were very receptive to allowing me, other mediators were very receptive to allowing me to shadow. So that's a nice aspect of it. It's a real community.
All right. One more question, Jill, to kind of get us set the stage for the discussion we're going to have is once the parties agree to mediation with the courts panel, how does the selection process work?
So there are a couple of ways that the parties can come to us. They can get ordered to us by a judge who just decides they should go to mediation, which is probably the least common. They can stipulate, or they can have an ADR phone conference with me where they're trying to identify what process might work for them. That would typically be for less sophisticated parties, or perhaps parties who are having trouble agreeing amongst themselves. But let's assume that one of those processes has happened. The case then comes to me and I look at the pleadings, I look at the procedural history of the case, and then I work with our database of neutrals to identify folks who have the correct expertise. Because I run the practice groups and I work with all of the neutrals pretty intimately, even though I'm relatively new to this position, I already know many of them pretty well. And so I'm able to really identify not just what their cold skill set is, but also some of the softer skills that might make them particularly appropriate for a specific case. So typically I will make that evaluation. I will assign mediator and they will then check conflicts, assuming they have none. In due course, they will reach out to the parties and let them know that they have been appointed. The parties then have an opportunity to object if they have, perhaps there's an associate on the team who wasn't obvious and might cause a conflict, something like that. They can come back to me, but short of that, once the assignment process has happened, they move off into mediation. And it's a very similar process for early neutral evaluation.
All right, thank you. Judge Kim, can we turn to you and ask you for a view from the bench? Are there advantages for the parties in using the court's ADR program as opposed to going straight to a settlement conference with a magistrate judge or some other provider?
Okay. Well, first of all, let me just say that even if you ask for a settlement conference with a magistrate judge from your presiding judge, you may not get one. Our policy is that you have to have a reason, either because a governmental agency is involved or because people need to have a magistrate judge for some particular reason. So even if you want a magistrate judge, you won't always get one. So then your choices are sort of private mediation or our court-sponsored mediation. And I think that the advantage of our court-sponsored mediation, number one, it's free. You get 4 hours of free mediation, which is wonderful for cases where sometimes there's asymmetrical resources. One party might have no money and the other party has money, and so they just can't afford to go to a private mediator, even though it's a kind of case that should have mediation. And so that's probably our biggest advantage. The second advantage is, as Jill said, our mediators are excellent. You can look and see who they are in advance. Many of the people are the same people you get in private mediation anyway, but the quality is very high and they get training from the court, which I think is different from the private mediators. So those are a couple of the advantages. But I think that Mindy and Vishal have good ideas about what the advantages of our court system are as well.
Yeah, I mean, I think there's two that I'd like to mention. One is especially with some of the intricate IP cases, that I deal with on a daily basis. The mediators that we have on our panel, they're dealing with this they're also dealing with this on a daily basis. They're up on all the case law. They've appeared before a lot of the judges in the Northern District recently. And so they can be really helpful in helping the parties to resolve that, where, the private mediators are all wonderful and we use them frequently too, but for many of them, it's been a while since they've been active in front of judges. And the other thing I would say is, in the unlikely event that there are any issues that come up with the mediation, like somebody violates confidentiality or there's something like that, by using the court's process, that empowers both the ADR office and Judge Kim to actually help resolve these issues. And you don't have that ability when it's in private mediation. And I have had to resort to that once in my 25 years practicing. And it was incredibly useful to have that as a resource.
I was just going to add to Mindy's very good points. The chance that you can get Mindy should be reason enough that you would choose private mediation with all due deference to Judge Kim. But also there's that distinction between goals and an objective. What happens is lawyers are sometimes so focused on the goal of winning, and they bring that same mindset over to a private mediator because the private mediator has maybe been in private mediation for so long that they've been divorced from the business and realities of representing a client. Whereas the court's mediation panel, many of us, like myself and Mindy, we know what it's like to work with a client. So the goal is not always to win, but to focus on what's the objective, right? You could resolve one case here, but there could be another case in another district or another country frequently, or you might be able to craft a business resolution that involves being in business together. There's a variety of flexible approaches that you can do through the court's panel that perhaps are not available otherwise.
Okay, thank
Yeah,
you.
Jonathan, can I add one thing? Because I was a practitioner in this district for a long time before I joined the panel. I also found that the court program was the one that was easiest for me to convince a client to use if they didn't think they wanted to mediate and I knew they should. And if they thought they didn't want to spend the money or they thought it was too soon and I disagreed, but for reasons of client relations, didn't feel like it was worth pushing them too hard. Sometimes I would go to the court process, and that meant that sometimes it was a little premature and we didn't necessarily settle. And that's okay, because what it does is it helps parties get to a posture where they can settle pretty quickly downstream. And I frequently used it in that, mode when I was on the other side. And I would add one other thing about Judge Kim is absolutely right that the settlement judges, you may not get one. To put a finer point on it, there are 13 magistrate judges in our district, and 9,000 cases filed in 2022, and something more than 13,000 cases were pending. Those are civil cases, by the way. So if every case has to go to a magistrate judge, that's off. You can see that might be a time-consuming process. And by the way, only 0.7 cases in our district go to through to trial. So you do the math. They're resolving somehow, somewhere. Yeah.
I think it's always helpful to hear the numbers and really understand the scope of what is happening in the court and the role that mediation can play to help, clients. Vijal, can I come back to you and ask you, if we focus on like high stakes cases, you and your firm bring cases to the ADR department. What are some of the factors that you consider, and how do you advise your client about that? How do you get it to come in for mediation in a high stakes case?
Well, most of my practice relates to computer software and hardware cases. And so we appreciate the fact that there are folks on the mediation panel who have that experience. It's a bit of a repeat of what I said earlier. It's those who have the experience and who've been on both sides. I personally don't care if someone is a plaintiff side lawyer or a defense side lawyer, because when you're in the practice of intellectual property litigation, you already know what the arguments are on both sides. And so it's helpful for your client, though, to hear it. So sometimes I even prefer someone who maybe brings a different perspective. So even though 90% of my cases are defense side cases, I appreciate the fact that a plaintiff's lawyer or someone who specializes on that side would bring that perspective to my client so they can hear that directly.
All right, thank you. Mindy, did you have some thoughts on that topic as well?
Yeah, I mean, I agree with Vijal. I think that the fees are often an issue. I do a lot of trade secret cases, and we often have that inequitable money arrangement where whichever side is accused of stealing trade secrets often is a startup or an individual and may not have be able to afford private mediation, and so those cases are for a money reason ripe for the courts program, but also you know, again, they're so fact specific, and there's so much kind of going on that I really value the experience that, you know, my colleagues on the panel have in trade secret cases. It's been invaluable.
And, you know, I'll add one other item. It's really the flexibility. You know, I think all of the panelists have touched upon this. In our district, we're very adept at thinking outside the box, and maybe it's because we live in the technology hub of the world that we want to be innovative, but we are innovative when it comes to the court's ADR program as well. So if during our first pre-mediation phone call, if both parties have a different idea of how to progress the case, maybe engage in 2 sets of briefing, maybe engage in a repeated number of pre-mediation phone calls, perhaps having phone calls that both parties know about, but that are only with one side and perhaps the clients, all of those different steps can really help lead to a successful resolution, whether at the first mediation or later. Sometimes in private mediation, we were joking about this as we were preparing for this call. Sometimes the first time you meet the person is the day of the mediation. And that's not as efficient as many of our panel members would hold a mediation. So thanks to Judge Kim and Jill for instilling some good values upon us.
Yeah, I agree. And I, you know, we also have normally a joint caucus, and in private mediation, I almost never see that anymore. And as before I was on this panel, I had a very large issue with joint caucuses. I was worried that it would derail everything before it started. And now through my experience, I've seen how valuable it can be. There are some cases where, you know, the parties are just too volatile, but those are few and far between. And they really can help focus the parties in on the issues and get ready to resolve things.
Yeah, Jonathan, if it's helpful, I can explain a little bit about our process is actually fairly unique in that once a case is assigned and the mediator begins the process, they do something which Bijal just referenced, that we would hold a pre-mediation call. And what that does during that, there's a list, and you can look in the ADR local rules about all the things you're supposed to discuss. But what happens is they talk about structural impediments to settlement, things like who needs to be there, what is the timing, and it allows us to really set the groundwork for a very productive session once we actually get going. And there are many neutrals on our panel who are also private mediators in their own right, and I would say more than a dozen of them have told me that they liked the process in the Northern District so much that after they joined our panel and went through our training, that they adopted that into their own practice, because that really allowed them to have a game plan for a successful mediation. It allowed them to understand what the parties were going to need to move forward meaningfully. And so that's a big part of our process.
Yeah, let's talk for a minute about the timing of that too, because that call happens pretty quickly after the assignment, and the assignment to the neutral in our court is happening against the backdrop of a deadline to complete the process. And I think, and please, Bijal and Mindy, correct me, I think that's usually accelerated as a timeline compared to what's happening in the private sector with the big providers.
Oh, absolutely. I mean, especially if you're trying to, you know, schedule with one of, I guess, for lack of a better word, popular private mediators. I mean, sometimes you're scheduling 6 months out. I had a mediation in a healthcare case a few years ago, and the only time we could get was a Saturday 8 months out with this particular mediator. So, you know, we can usually schedule things very quickly. And if for some reason a mediator does not schedule that call quickly, we get an email from the ADR office saying, hey, you got to do this. This has got to happen right now. And you know, it does. And that's not to say that the mediation has to happen that quickly, because one of the things that is great with the flexibility of our program is if it's not the right time for mediation, we're going to find that out in that pre-mediation call. And we're going to work with the parties to see if we can extend the deadline for the mediation to happen, to make sure that whatever needs to happen to make that most successful happens before the mediation.
Yeah, I was just going to add, the timing is crazy. I mean, a personal anecdote is I did call just yesterday a mediator at a private mediation service in Los Angeles, and this person was booked out for 12 months. And which is absolutely crazy to me. And the clients felt that they really wanted someone who had worked on at least 20 patent cases. that's kind of a hard bar to find. But our mediation panel is filled with really experienced practitioners.
Yeah, most of the people on this call have worked on 12 patent cases. Okay, I would add that the court is really, if the parties are working towards something, even if they get referred to an early ADR conference and it feels premature to them, as Mindy said, they work with the neutral and then can often submit a stipulation to the court, and the judges are pretty amenable to working with them if there's something that looks like progress.
All right. Let's talk about some specific categories of cases or types of cases. I was going to ask to start with you, Bijal. What kinds of cases do you think are really well suited to bring to the program? And is there a success story that you could share with one of your cases?
As a litigant, right, Jonathan?
Yes, as litigation counsel, yes.
So I have a very interesting practice. Some might say boring. So I would say 90% of the litigation matters I work on are patent cases and 10% are copyright and trade secret. So I would say complex IP matters are really great to bring to this court, particularly because I don't want to I would like to emphasize the role that diversity brings as well, because so many of our clients have perhaps leadership team members or the persons responsible for the litigation that are international, that come from another country, that's where English isn't their first language. And everyone always feels at home in the Northern District. And I can't say that's true when I go to other states for mediation. I mean, there is a definite stark contrast in the receptivity to somebody who might need a translator, somebody where English isn't their first language, or someone who is really nervous about being, in front of a quasi-judicial officer. And that doesn't happen here. So from my perspective, it's both having a set of mediators that are receptive to various types of clients and who have the experience. And as Mindy points out, timing is critical. You don't want to spend the money. You don't want to wait a year to go to a mediation, right? By that time, the assigned district court judge is going to have you continue on with your case, right? They're not going to stay the case because the mediator that you chose happens to be busy for 12 months.
No, I agree. And I think the other thing that I would add, and I'm kind of the flip of Bijal, I do a few patent cases, but mostly trade secret and complex commercial trademark copyright cases and some healthcare. The other thing that can't be underestimated is the power that we have through the courts program. Every once in a while as a litigator, it's really important, whether it's if the mediation is in person, that the parties be there. And if you go to private mediation, the private mediator has no power to make people show up. Whereas it's expected if it's in person, they're going to show up. And if it's virtual, it's expected that people, with power to settle the case are going to show up. And if we know in advance that that's not going to happen, and there are procedures in place that where you can go and get help to make sure that that person's showing up. And if need be, you get a court order requiring that person to show up. And I have had to resort to that in the past because, the case is not going to settle without that person with authority.
Yeah. Okay. Thank you. Tell you what, let's talk about success stories real quick. I'll get the ball rolling. I had a matter of, it's been a number of years ago, but as litigation counsel, where it was a personal injury case, damages were relatively fixed. There was some dispute about damages. Liability was fairly clear, but there was a little dispute about liability. But the whole mediation session pointed all the participants to a need for an apology. And the clients that were there, understanding the moment, rose to the occasion. The defendant in that case really did a very heartfelt, complete apology that wasn't one of these conditional, caveated statements. And it was such a memorable experience. It's been probably a decade since that happened, and I can still remember very clearly what it felt to be a part of that proceeding. It was really terrific. So that's my quick success story. But do other panelists have as litigation counsel a story about a case that they want to share?
I mean, yeah, I mean, again, as part of it is, this is definitely a community of attorneys, both the panel and the Northern District practice. And so there's a trust built up with the panel mediators, whoever I might have. And that really allows me, when I'm representing a client, to feel comfortable and free to actually share as much as possible with them. And it has resulted in so much better resolutions for my clients. I always joke that I know things are going well if I don't talk to the mediator that often when I'm litigating, but I find that even if our case is going that way, we're still chatting with the mediator, and they're connecting with my client and getting to know them in a way that really puts trust in my client and trusts the process. And so it's not a specific story. It's just an overall, I'm incredibly satisfied with our process and our neutrals.
I will share a success story that's going to sound very new agey and very probably perfect for the folks that are here in the Northern District. But I took some of these concepts and also some of the concepts that I've learned and now incorporated into my own mediation practice, which is sometimes litigants just want to be heard. And one of the effective ways of doing that might be by getting everyone in a joint caucus. I've now employed this of touching a rock. I haven't gotten to the part of asking everyone to hold hands for a minute, but it is amazing how the vitriol in the room will subside with something as easy as, everyone, there are 6 rocks. Please, let's hold the rock and take 3 deep breaths. The reason I say this is because the whole point of a mediation program is for the parties to come up with a resolution as opposed to the law. If the parties come up with a resolution, both parties might leave upset, but they find some fulfillment in the fact that their issue is resolved. And in the court system, with all due respect to Judge Kim and the wonderful judges in our district, you might have an appeal, you might go to the Supreme Court, it may come back for remand, right? There's no finality. And in this way, there's finality. And from my perspective, that's extremely important.
I'll echo some of the things that you all have said. As a mediator, I've actually had a case settle with nothing more than an apology exchanged. Somebody just needed to explain what their situation was, wanted to be heard, and wanted the correct people to show up and actually hear it and say, I understand, and here's the Fair Housing Act issue that prevented me from doing what you wanted to do, but I also would have liked to have done what you wanted to do. You're not wrong, it's just the law prevents it. So that was all it took. I actually settled a case like that. And everybody doesn't, our program doesn't require that the neutrals, make everybody hold a rock or hold hands or anything like that. What we do is we empower the neutrals to find out what's going to work for them, and also make sure that they have enough pre-call, the pre-mediation call, so they can assess what will work with the parties. That wouldn't work with every party, but with some parties, it works really phenomenally well. And, some mediators can't pull that off and it would look hokey, but where it does work, it can actually be really powerful.
Yeah, I have to say, I don't think I could pull off the holding rocks, but Bijal, I would love to see that.
Done.
Yeah, I think we all would. Yes.
These are the benefits of being in the peninsula where we have rocks as opposed to San Francisco, but that's a whole other story.
Let me ask, as litigation counsel, in a case where maybe it didn't settle in the time provided through the court's program, have you had the experience of later engaging that neutral for additional services as a private mediator?
Yes.
And
they were very helpful.
Yeah.
When it doesn't settle, often without even asking, we get follow-up calls or emails. Hey, checking in. How are things going? I mean, I know I do that when I'm mediating as well. And sometimes we just need that little push, or sometimes that mediator's proposal a little ways down the way that will actually resolve the case.
Yeah,
They're not required to.
Correct.
But our neutrals are not required to do that, but often you can see how passionate they are. They will often do that just because they are so invested in getting the case settled. Mindy Bijal, they'll call people on their own time, even though they're not required to.
Yeah, and you know, think about it from the litigating lawyer's perspective. It's helpful because they then have to report it to their client, right? They're duty bound to report to the client, like, hey, our mediator, Mindy, called and wanted to know where we were. That alone might be enough of a nudge to move the process along.
Absolutely, yes. So one more question on this, as litigation counsel, has it been your experience that using the court's mediation program has saved your clients money over time? And could you talk a little bit about the ways in which that is the case?
Wait, this is against my interest as being a private law firm lawyer, but yes, we will answer the question. I mean, I guess I'll go first. 1,000,000%, right? Because not only does it save money in the litigation costs, but it helps you build more trust and a better rapport with your client. And so if you're in this business for the long term, that's worth a lot more than making an extra 10 hours off of a case.
Yeah, I agree. And, you know, look, I mean, some of the mediators that are my go-to mediators they're wonderful and they do a great job. And many of them also serve on the panel. But if I'm hiring them outside the program, we're talking tens of thousands of dollars. For some of my clients, they're not able to do that. Or for some of the opponents, they're not able to do that. And so it absolutely has saved money. And the fact, as we alluded to earlier, that we can get into mediation so much sooner, that means we're not doing all that discovery. That means we're not having motion practice. You know, as much as we like to appear in court, you know, that they cost money for our clients. And so being able to do that, even if it doesn't resolve it, we've maybe now at least narrowed the issues that the parties need to decide. And that is, when cases don't settle, I find it's usually there's a couple issues that they need to go to the court for resolution before they can resolve. And they usually do at that point.
I would say that it is not uncommon in our panel when the parties are unable to settle for the mediator to follow up voluntarily, as Judge Kim noted. The panelists are required to donate 2 hours of time of prep work and 4 hours of time for session. They aren't required to donate more than that of their time or volunteer more of their time, but most of them, I would say, do. Many of them do. You know, folks do often come back to them, and they can either come back to them and self-pay with the traction of having already gotten all that information, you know, downloaded. And even when they don't do that, a lot of what we focus on, because it's a court adjacent program, we recognize that our job is to help the parties and the court move these cases forward in an efficient way. It's slightly different focus, I think, than private mediation. And so sometimes we'll retrench and we'll say, well, maybe you can't get a settlement today. Are there things, do you want to talk about a discovery plan on what would get you ready for mediation or get you ready for the settlement conference? And in that way, they're really focused on making their case more efficient. And I, as the director of the program, do consider that a success. It doesn't show up on our settlement numbers, but it is a successful strategy.
Just to further emphasize your point, Jill, I don't see any downside as a litigant from participating in any type of ADR process. It helps you focus, it helps you crystallize the issues, and more often than not, you give a lot more thought to the remedies that you would get, even if you were to prevail, which many times could lead to a settlement.
Absolutely. And you get kind of, oftentimes as a litigant and as a counsel representing litigants, I tell my clients, look, this is what you're facing. And, hopefully they believe me, but they believe me much more when they hear a neutral say, hey, these are the issues that you have. And I'm like, gee, didn't I just say that to you a few days ago? And it's got a little bit more authority when it's coming from a neutral. And that's been invaluable as well.
So one of the things, so we're talking about the benefits of the program, and I think we just scratched the surface. There's a few more areas I want to get into. One is this idea that isn't there a survey that's sent out, Jill, after the completion of the process? And can you describe sort of what role that plays in the administration of the program?
Yeah, absolutely. The survey is sent out to all the participants in any mediation or any evaluation session as well, anybody who comes through our program and goes through an ADR session. And it has a lot of different categories, including, did the neutral give you evaluation on your case? Did they improve communication? Did they save you money? How fair do you think the process was? And we get a decent response on those. Not everybody responds, but it serves two functions. One, we can see where people are doing well, where they might need some more support or training. It also helps us to explain to the judiciary what we're doing and why this program supports them well. So it's really very important. And I do look at every single one of the surveys that come in. And when there's something that can be shared with a neutral, I will share it with them. But for example, if somebody had an issue with either another party or with the neutral, they can confidentially report that in their survey. And I have had a very few, but some responses where I thought, I should really follow up with the neutral and find out what happened in that situation. And so it provides a lot of ways of accountability. It also allows us to look at what's working and what's not, both on a micro level in a particular case, but also on a macro level for the program. There's one other advantage that's sort of related to the survey, and it's the people who are administering the survey. A very important advantage that we have here is that this program has been going for a long time. It started in 1985 with early neutral evaluation, but added mediation in 1993. And for much of that time, we have panelists who've been on that panel for ever since then. But also we have a staff that have worked here for 30 years. They help administer that survey, and they help do case and program administration. And anybody who's come through the program would know Claudia and Alice, who administer that. And from my colleagues who've left here and gone into private mediation practices, they've said, you don't appreciate how good your case management is until you got to private practice. And that's no diss against any of the private practices, but it's a different business model. Here, we are very, very keenly aware that it's our job to serve the judiciary and the parties. And it's not about money, it's about making sure that the process is done appropriately. And so we take it really seriously, and our staff is really experienced with that and very, very efficient. I got my hand slapped when I first got here for trying to calendar things, which is a good thing because they are way better at it than I am. So that's a very distinct advantage that some of my colleagues who are in private practice mediation have pointed out to me. And as a private mediator, I can agree.
And
Yeah.
kind of a corollary point, Jill. It's also, in my experience, how invested the judges in the Northern District are in this program. There have been several times when I've actually gotten handwritten thank you notes from the judges on the case for mediating the case, and I still have them up in my office. And it means so much that they took the time to do that, and to me, that says that they really see the importance of this program for the court.
I was just going to add, well, I can't comment on calendaring because I'm horrible at it myself, but I can comment on the fact that Jill and the entire staff take confidentiality very seriously in accordance with the local rules that we have. I can't say the same is true in other parts of the country, where sometimes the mediators seem to somehow share information with the assigned judges. And so, Jonathan, just returning back to your original question of why is our program more favored, confidentiality is really key. Because I know that nothing will get back to the assigned district court judge.
It's a really good point. And that is why we have our own assigned magistrate, ADR magistrate judge, Judge Kim. If anything comes up that I'm not able to handle as the program director, I do have a resource that is not the sitting judge, somebody who is separate and apart from the litigation, court.
So in other words, this judge who's presiding over the case is not going to hear about your fights during mediation. Did someone spill confidential information? Did someone
Correct.
not show up? I'm going to deal with that if Jill can't. And so that's actually nice because you're insulating the judge from that process. I would also say that even for our magistrate judges, we and the judge who's presiding over the case, even if it's my friend next door, we will not tell them anything substantive that's discussed during the settlement conference process, because as a court, we feel so strongly that the process of trying to settle the case should be completely divorced from presiding over the case. And that's our court-wide policy. And nobody has ever asked me questions about the settlement conference or the mediation process.
And I will say, I wish that all of the other federal courts did that. I have appeared in several courts where the magistrate judge assigned to your case does a settlement conference with you. And then if it doesn't settle, proceeds to do your discovery. And
Yes.
there's never anything I do during a mediation that I would be ashamed about. But it's uncomfortable.
And your clients don't have any faith in it. They don't feel
Right.
comfortable.
Yeah, and by the way, I don't have very much faith in it either. I think that if I'm doing a mediation in front of a judge who's hearing anything relating to the merits, whether it's discovery or otherwise, I am not as candid.
Yes.
Absolutely. It's human nature. It makes no sense. So that's very important in our process. And I also work with the magistrate judges to support them when and so I know that they take that very seriously. We, in this district, there's a real separation between confidential ADR discussions in whichever form they are.
One thing I appreciate about the design of having the ADR magistrate preside over the ADR program for those key issues is sometimes parties come to the planning call and they don't want to send the corporate vice president or the executive claims handler or whatever it may be. And I can just say, you have to be here. It's a matter of local rule, unless you make a motion to the ADR magistrate. And so it doesn't get tangled up in what I'm trying to do. And there's consistency because one person, a judge, is deciding those issues. And so I think that design feature is really, really one of the hidden strengths of the program.
Well, that's right. And it also allows for, if there is a real reason, it allows for us to escalate to somebody who has the authority to make that decision. In this case, Judge Kim. So it allows for that if it's appropriate, and it takes it off the shoulders of the neutral if it's not.
And it helps the litigants because it makes sure that you'll get the right people there.
Yes.
And then if there's a problem, you have a way of adjudicating it without going to the judge who's handling your case.
All right, so in our remaining time, let's come back to Bijal and Mindy and ask now as neutrals. Maybe we'll start with Mindy this time. Could you tell us what types of cases have you mediated, and a little bit about how you go about preparing to mediate generally?
Sure. So I do a lot of IP cases, a lot of breach of contract cases. Interestingly, I've had a lot of cases involving wine, which has been fun. And a few ADR, a few disability cases, which I think almost everybody in the panel has had at least a few ADA cases. And generally what I do is, I read the papers. I go through any motions or anything like that. I make sure I kind of know what's going on. If it's an area that I may not be as familiar with, I'm going to look at a few cases just to make sure I know, what the key issues are. And then, I have the call, and if there's still questions unanswered, I might reach out, between the call and the mediation, to make sure, that they know what I need to know, or check in and make sure they don't have any questions. So, I don't just show up the day of the mediation and go, here I am, guys. I want to make sure that I'm putting in the time and they know that I'm putting in the time and that I'm as invested in this as they are, because I think that's really, as a mediator, to me, the most important thing is having the parties and the lawyers trust me and trust what I am saying. And so I'm always I tell them what I'm only going to share if you give me permission. Otherwise, it's confidential. And I'm very clear about that. Because that's how I help parties resolve cases, by being that trusted figure that they can ask open questions to.
Yeah, I don't have much to add to Mindy's very good comments. I really believe that a robust pre-mediation caucus and the briefing is really, really useful. And I also do make it a point to tell both litigants that I'm going to have individual caucuses, if you're both okay with it, after I get the briefs, in order to understand the parties' positions in much more detail than I could do it the morning of the mediation.
Okay, all right.
I only pause there because I have a disagreement with Mindy over one.
Yes, I was going to say that.
The mediation. So I don't know if this is the appropriate time to bring this up, but up to you, Jonathan.
Yes, please, go ahead.
So since I'm the rock lover, holding hands and holding rocks together, I'm a firm believer that mediation should occur in person. I believe something about being in the room together and seeing the energy from both parties that's really important. And it really helps the parties resolve the case, even if it's the fact that they've taken time out of their day to make arrangements to come to my office. It really shows that they're putting forth the effort and they're taking the process seriously. So for me, it's very important. And I will tell you that recently I did have a situation where if both parties do agree to do a Zoom, I'm fine with that. But both parties have to agree. I had a situation where one party was in Asia, one party was here, and the party in Asia said they couldn't get a visa to come here, et cetera, and they really wanted to do it on Zoom. But the US party said no, and I was pretty steadfast. I said, unless both parties agree, I'm not going to move it to mediation. They had to take it up with the judge, which ordered it to be okay by mediation because of the visa issues. But my personal preference is to have people in person.
Yes, and I now work mostly remotely. I think I've only been in person in court once since the pandemic, and I've walked in and I'm like, wow, this feels different. But all of my court hearings have been I've had trials, not jury trials, but judge trials by Zoom. I'm very comfortable with Zoom, and I see there's a lot of advantages for the parties, both because they may be all over the country, and also traveling in the Bay Area now is not the easiest thing now that traffic is back up where it is. And I understand that people have, childcare or other issues that, make it more difficult. So my practice is I have it on Zoom unless there's a reason to have it in person. I will tell you one that has made it much more difficult for me. I think the parties, at least in my experience, don't see as much of a difference, but for me, I've had to be much more deliberate about making the connections with the parties and the attorneys, and I do that, but it takes a lot more thought and effort. And I also had to learn how to use Zoom, not just show up and press the button. I now know how to do breakout rooms and all these other things that I never knew how to do, and that's been very useful in general as well. I don't have anything against in person. I just think it's more efficient for me, and I have not seen any effect on the parties for having it remotely.
Mental note, do not pick Mindy. I'm just.
Well,
Just kidding.
close.
I'd be interested to hear what Judge Kim and Jill think on this subject too, Jonathan.
So I am in favor of in-person. I switched back to in-person as my default. I feel very strongly that I'm more effective in person. I think it depends on the mediator, really. I mean, for whatever reason, I feel like I do a better job when I'm in person with people. And so that's my preference.
I agree. I feel like I bring more of my full skill set to the table when I'm in person. We're working through as a court what the program will be doing. The court no longer has any guidance in terms of, the judges are all doing what fits their own particular practice. And that is one of my projects for the next few months, is to sort out what we'll be doing. So stay tuned. But right now there's a combination of things.
All right, thank you. We have a few more questions to go over as a panel, but I want to remind our audience that they can send a question in by chat, and we will take up your questions. I would be happy to do that. So reminder to do that. We've got a few minutes remaining. While you're thinking about that, I share the preference for in-person, but I've also learned in the pandemic era that you just never know what is animating people sometimes. And I had a recent matter that I worked on where one party wanted Zoom and the other wanted in person, and I decided to go ahead with it. But I went back to the party that wanted in person, and when I realized they were traveling from out of state, and said, "Are you sure?" And they said, "Yes, we want to be there in person, even though the other side won't be," and we were okay with that. And it turned out there was a reason for that. There were people here in the area that they wanted to talk to, so it worked for them, and we had a lovely time. But it was surprising to me, as you might imagine.
I have had two mediations that I was participating in as a litigant, not as a neutral, that were hybrid, where one side was in person with the neutral and one side was not. And I have been on both sides of that equation, and I think it's odd, but it didn't seem to affect the mediation at all. I think people might think that it would, that by being in person there is some sort of advantage. I did not perceive it that way in that
Well,
situation.
I'm keeping
And-
that.
and-
Go ahead,
I
Vishal.
was gonna add, I am also cognizant that my mode of thinking might just be generational, and that the newer generation of lawyers and litigants and clients probably think I'm a dinosaur, and I need to be more open. I definitely do recognize
I think we're the same generation, Bijal, so I guess that means I feel younger. I don't know.
it. Perfect.
All right, I'm keeping an eye on the chat, and I will keep an eye on that. So please send in your questions. Jill, you had alluded earlier to the possibility of opening up the panel, that you hope to,
Yes.
and there would be a time for people to apply, and there'd be a selection process.
Mhm.
I wonder, Judge Kim, could you help us? Are there areas of expertise that or types of neutrals who would be something that the court would be looking for, or would be good to join the panel?
We want people who are good mediators across the board, but we do tend to find we are lacking people with experience in ERISA, and also people who feel comfortable handling civil rights cases as mediators. Settlement, the magistrate judges handle most of the civil rights cases, but we do send some of them to the ADR panel as well. And we would like to find people with civil rights experience. And Jill, you can outline some of the other areas as well, but those are the ones that leap to mind for me.
Those are certainly ones that I've had a lot of call for recently. There are also some sometimes banking, like the credit practices and things like that. And those are ones that, they may not be the sexiest cases, but they're also ones where if you have an expertise in that, you can really start to, hone your skills by doing them. And then maybe if you have some broader experience, you can do other things as well. So we do need folks who are in those areas.
All right, well, that's good. I know people in both of those areas. I'm going to be letting them know
Fantastic.
they can apply.
I just wanted to add, Jonathan, I mean, a small plug for the program, that it's really made me a better lawyer. It's made me a better mediator. It's made me a better counselor for my clients. So the program is really great. And it's really fulfilling when you work with pro se litigants, because this might be their only experience with the judiciary. And I'm super cognizant that I want them to believe that, there are reasons that we have the law and that it needs to be fair and equitable for all, and to leave them with that impression. So it's a really incredible experience and opportunity.
Yeah, I agree. And I've said that myself too. It's just like, it's really hard to be a good trial attorney until you've actually been through trials. And so many litigators don't do that. And it's the same thing by becoming a neutral and mediating cases. It really makes you a better lawyer all around, because you're looking at things from different perspectives, and you can be such a better advisor. And I will also say, and this isn't an advertised benefit, but all of the training that we do and the discussions that we have about being a good listener and connecting with people, I mean, that also works in your private life. The active listening that we all practice so much of has been invaluable dealing with my family and my spouse.
Yeah, I'd second that. Agree 100%. All right. So the panel hopefully will open. People should keep an eye out for that and should apply. And that'll be coming later this year or next year.
That's the hope. And if the folks look in the MCLE materials do provide some navigation about where to find that on our website. And even though it says it's not open right now, please put your name in, start your application, because once it opens up, we will contact everybody who's had an application in and said would give them an opportunity to update their application before we close it. So feel free to jump in there and get it done, even though you may not, even though it's not currently open.
All right, there was one area that we kind of skipped over. I was going to ask Mindy, since you're on the E&E panel, could you comment on what kinds of cases are best suited for that form of ADR?
You know, I've done in my many years on the panel, I think 3. And I think in 2 of them, I gave an evaluation, and in one of them, because one of the kind of procedures that we have in place is before we give the evaluation, we give the parties a chance, and at least I do ask them if do they want to hear my evaluation or would they like to try to mediate this before I say anything. And so once they decided they did not want to hear, the other 2 they did. And I think it works best when the lawyers on each side trust each other and know, have an idea of what's going to happen, with the presentations that they're making. One of these cases, one side had absolutely no idea what the other side was going to say and were shocked by it. And it turned out that the side that that side was actually, in my evaluation, accurate in stating the law. And so the side that was shocked then heard from me that yes, my evaluation is this, and they really couldn't recover because they weren't expecting that. So I think it's important for the lawyers to do their homework before an E&E and to educate their clients, and also to really work collaboratively with opposing counsel if you want it to be successful. And it's an incredibly powerful tool, because there are those cases where both lawyers agree that this is what the law is, but the clients haven't bought into that. And having a neutral who they don't know come in with, the panel behind them and say, this is what my evaluation is, that can actually move them in a direction towards resolving the case. And so it's I think it could be used more often than it is. I think not enough people know about it.
Yeah, I'd like to give a little pitch here to E&E as well, and that in areas that I think we're underutilized. And I should point out that the evaluators we do have a panel of overlapping evaluators and mediators, but in order to be an evaluator, you have to have a 10 years of experience in real expertise in an area. So we have some folks who are very, very sophisticated in the areas in which they provide evaluations. And Mindy's exactly right. We go through the process with them. The parties present their information. And then before the evaluation is rendered, if they would like, they may move directly to a mediation. They may not. We have a pretty high success rate actually in terms of settlement coming out of those E&E sessions, surprisingly. And even those that don't settle right at the time, many of them settle within 30 or 60 days. So they're pretty successful. The area that we actually have a lot of really, really qualified folks in is IP. And it rarely gets used there. And I've talked a little bit about with Judge Alsop, because those are the cases that really could benefit from some, ADR intervention. And I actually think that it would be really beneficial in a bunch of those cases. It's not binding, but it's certainly educational. So even if you aren't going to adopt it, and there's always a concern, I know, in the parties that folks will get more entrenched in their positions if there's an early evaluation. But I think that that's largely not a big problem for the patent cases. Frankly, they are going to roll out how they do, but it's really educational to get before an experienced practitioner in that role. So I would love to see a few more of them come through. And if you want to look at our, panel, you can look at expertise and you'll see that we have folks that are actually very experienced in that area, many of whom are private neutrals or, some of the people who wrote the textbooks on the most current IP laws. So that they're really sophisticated.
Yeah, Jill, I agree. I think trade secrets, I haven't seen it in my practice yet, but I think trade secrets would be another kind of law that would be really well suited for an E&E, just because those cases move so quickly, and having some evaluation could cut down on a lot of costs and court time, and I think really help the litigants who might be a little entrenched, because I love those cases because they're a little bit soap opera-y, and that neutral evaluation could really help.
Yeah, I agree. And I did a lot of trade secret cases as well in my private practice, Mindy, and I always used the courts panel if I could, and mostly did, but didn't use E&E, and I think that was a miss.
Yep.
All right. Well, thank you for explaining that aspect of the program. And I see we've reached sort of the end of the hour. Jill, if people have questions that they haven't been able to put in the chat, but they'd like to pose, to the program? What should they do? Send you an email or?
They can contact me, and my contact information is on the last page of the MCLE materials that were circulated. And so they can feel free to reach out to me directly. That'd be great. Please
right.
apply, send your cases. We'll take good care of you.
All right, well, and thank you to all the panelists. Really appreciate your time tonight. And I think with that, we are adjourned.